fairly new. So she's immigration, right? And she's really, really quite good. But she's also nice. And doesn't, one of the things we like about our faculty is that we have very input, knee-jerk reflexive way.
Oh, so I mean, you're almost always going to do like 6 months or so. Probably some more.
Interpreting the same phrases.
Right, in a way that is just.
First tour.
However, since I said you, that's what you do with it, right? And so I don't have a. I'll be interested to see what you say with it.
I'll work this in.
How do you like South Texas? It's an interesting place for someone with your sort of ambitions.
I do quite well there.
No, I know. It's I've always had. I mean, we always had. The student body was interesting.
Hey Josh, would you mind grabbing me a plate, please? Just some chicken and rice. Just I'll eat a little bit later after thing's over. Thank you so much, sir. Appreciate it. I see you.
Hey Josh, how are you?
Oh, look at this! Last time I came here, you weren't here. Why don't you get in check?
Why don't you go get a birthright citizenship? Just mix it up.
I think I know what I probably follow up after here.
I get plenty of these opportunities to go and debate people I don't really have to do it.
Yeah. I think I saw you were going to ABM.
I'll see you twice. Well, I'm going home tonight. I'll teach you Wednesday, and then going back to the ABA Thursday. So I move around.
Hey, Brooke, how are you?
What is the topic?
We can argue like drafts, and then I'll be
So on the other end, yeah, very good. I think he's trained for that. Is that one? I
did. I was like, yeah. I was like, that's
How are you, Professor? I call you that now?
not even.
Awesome. Yeah, just a minute.
I am awesome. What's going on with you?
Are you teaching this term? Good for you. I'm teaching first time this spring.
Are you? I really like to do more.
Well, we have a case book with a couple of different chapters, which is good enough.
Yeah, sign your book. That's what I need to do.
I know I'm in trouble.
I just do it.
Awesome. Can you stick around for this?
This is as front as like I've ever seen in your class or anything. So
I don't know what to say. I'll figure it out. I'm just going to talk about birthright citizenship.
Yeah, figure out the United States.
I say nothing. Yes.
I just sort of show up and start talking.
So you can sit in the front, and I'm like, okay. You have the cards. Oh, like my other stuff's back there. Yeah.
science, one I've heard is supposed to be that children of like invading the class. It's kind of higher series. Turns out it's better six years. That seems right to me.
I think we'll give it just a couple more minutes and then we'll give you a set. That's where you want to be?
That's fine. That's fine. I found it. So do you want me to open it and then turn it over to you?
Either way.
The other bio.
The other bio's right here. I'm just going to read them.
Good afternoon, everybody. Good afternoon, everybody. Thank you so much for being here. Sorry if I look a little bit weird today. I have a pinched nerve. It's a little bit quasi-motor right now. But thank you so much for being here today. We're very thrilled to have two amazing speakers. Before we get to introducing them, I'd like to welcome those who are here for the first time to the Federal Society. We'd love for you to come. This week we have another event on Thursday with Christina Sandifer from the Goldwater Institute, and we will also be hosting Mark Brinton, the General Counsel from the Utah Medical Association. Next week we'll be hosting Judge Griffith from the DC Circuit, as well as Amanda Tyler from University of California, Berkeley Law School. They'll be talking about habeas corpus during wartime, and this Thursday event is going to be we will be talking about right to try and how terminally ill patients can try non-FDA approved drugs. Well, thank you so much for being here, and I'll turn time over to Allie. Thank you.
Good afternoon, everybody. I'm going to introduce Professor Blackman first, and then I'll introduce Professor Stansel as well. Josh is a professor of law at the South Texas College of Law, Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Josh is the author of the critically acclaimed, unprecedented, The Constitutional Challenge to Obamacare. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Josh has testified before the House Judiciary Committee on the constitutionality of executive action on immigration. He is an adjunct scholar at the Cato Institute. Josh is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the Internet's premier Supreme Court fantasy league.
You should all play.
And blogs at joshblackman.com. Josh leads the cutting edge of legal analytics as director of judicial research at LexPredict. Josh is the author of over 24 law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. Josh clerked for the Honorable Danny J. Boggs on the U.S. Court of Appeals for the Sixth Circuit, and for the Honorable Kim R. Gibson on the U.S. District Court for the Western District of Pennsylvania. Josh is a graduate of the George Mason University School of Law. Now, Professor Paul Stansel joined the BYU Law School faculty in fall of 2014.
They know me.
Well, I'll skip to the
It's
end.
just less impressive, and so I'm telling myself here.
For those of you that don't know, before entering teaching, Professor Stansel practiced antitrust and intellectual property law as a shareholder of Godfrey & Kahn in Milwaukee, and as an associate at Baker Botts in Houston and Crenshaw, Dupree and Milam in Lubbock, Texas, and he did that for 10 years, and he earned his JD Order of the Kuwait from the University of Virginia School of Law. So please welcome both of our speakers, and we'll hear from Blackman first.
Thank you so much. The topic today is the legal resistance, but I also want to birthright citizenship for him. I promise. I will work. One of the joys of being a law professor, at least in this time of the world, is that every day you wake up and there's a new constitutional issue to think about. It just seems that way. So today is birthright citizenship, but this will actually play into my talk. So the constitutional issue, right? The 14th Amendment begins, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside. Okay? Why is this provision in the Constitution? The simple answer is to reverse Dred Scott. Right? The basic issue in Dred Scott was whether a person of African descent could ever be a citizen. Even if granted state citizenship, could they be a citizen of the United States? And in the infamous opinion of Dred Scott, Justice Taney wrote that no, they can never be citizens, even if their state grants them citizenship. In one fell swoop, Section 1 of the 14th Amendment reverses Dred Scott, says no, if you were born here, you are subject to our jurisdiction, then you are a citizen. But why is this important, right? We didn't start off with the 14th Amendment. In the years beforehand, we had the 13th Amendment. And the 13th Amendment said, involuntary servitude and slavery, no more. Right? That provision eradicates slavery. But it did do more than that. In 1866, Congress enacted the Civil Rights Act of 1866. This provision sought to grant citizenship to all persons. It sought to make the slaves, the former slaves, citizens. Right? Now we know that President Johnson vetoed the Civil Rights Act of 1866. He said it was unconstitutional. I think he was right, I don't know. But then Congress ratified the 14th Amendment in large measure to constitutionalize the Civil Rights Act of 1966. So this notion of citizenship is a very important aspect of our history. Now, what does this phrase mean, subject to the jurisdiction thereof? I want to go back to the Civil Rights Act of 1866. And that statute gave citizenship to people born in the United States who were not subject to any foreign power. Not subject to any foreign power. That phrase is broader than subject to the jurisdiction. With the 14th Amendment, they actually shrank the limitation. As long as you're subject to our jurisdiction, you are a citizen. Now, what does that phrase mean? Most scholars, not all, but most scholars agree that that means you're subject to our laws. That is, if you come here on a tourist visa and you run a stop sign, guess what? You're getting a ticket, right? If you come here and you engage in mail fraud, guess what? You're getting a criminal indictment. The idea of subject to the jurisdiction, in my opinion, and there's debate on this, I think means people are subject to our laws. So if you come to this country and you're subject to our laws, then you're subject to this jurisdiction. And you get birthright citizenship. Now, what's the other argument? And I always try and be fair, I give both sides. The other argument is this means loyalty, allegiance. And if your parents have allegiance to a foreign nation, then you're not subject to our jurisdiction. I think that's a hard argument to make, and we have some precedent going the other way. So one case is Wong Kim Ark. And this was involving a person of Chinese descent who was born in the United States. And the court held that he was given birthright citizenship. Now, there's a wrinkle which some people raise in that Wong Kim Ark's parents were here lawfully, and the argument is if your parents aren't here lawfully, they're not subject to a jurisdiction. That's a question the courts have not ruled on, but one I think is pretty conclusively resolved by history. There's debates in the framing of the 14th Amendment which say, wait a minute, we really want people coming here and being citizens by accident of their birth? And people say, yeah, that's fine. So I think that issue is more or less resolved. And why am I talking about this in a discussion on legal resistance? Because President Trump is quite unique, unprecedented, you might say, with an S, not a C. Since he's come into office, he's pushed nearly every boundary you can think of in terms of what he can and can't do. And I've been a sometimes critic of President Trump, and I've been a sometimes defender of President Trump. I didn't vote for him, I don't plan to vote for him again. But I do think some things he's done within the law and some things there aren't. But what's unique about President Trump is that the idea of norms doesn't really bind him. And what do I mean by that? If we've had a settled understanding in American law for 100 years that people born in this country are citizens by virtue of their birth, most presidents would say, okay, shucks, I guess that's it, right? Right? We have this long-standing understanding, let's just keep things where they are. But that doesn't faze President Trump. He says, they're telling me we can do this. Who's they? I don't know. There's always lawyers, but I couldn't tell you, right? But they're telling me we can do this. Why is it significant? Because when the president takes an oath, and he took that oath, he gets power that's unique, that no one else in this republic has. He has the power to protect and defend the Constitution. And that's not to protect and defend the Constitution as the Supreme Court says it is. That's a common myth. Right? The president's oath exists outside the courts. Every day the president makes decisions on whether he can or can't do something. The same way if you're a police officer and you say, I want to pull that guy over, you don't ask a court first. You say, you know what? Based on my understanding of the Fourth Amendment, I can make this traffic stop. Right? All members of government decide constitutional questions on a daily basis, but the president has an oath to do so that's unique. So usually, when the president's making decisions, he's advised by his lawyers. And what happens if his lawyers say, Mr. President, the court's cases say you can't do this? The president can say, okay, I guess that's it. Or the president can say, find me another way, right? Or find me another lawyer, right? So you have this process of the executive branch where you have a president who doesn't find himself down by norms, but ultimately I think generally listens to his lawyers, which is why I think this proposal to do whatever with birthright citizenship is just a scam. It's not real. A week before the midterm elections, just gin up some attention, start talking about something other than bombs and shootings, right? Just move the attention somewhere else, which he's very good at. But why is this important? Right? Why am I bringing this back into legal resistance? Were the president to actually try this, right, it would be met in court almost immediately. And I think the courts would fairly quickly say that the president can't use his executive action to rescind birthright citizenship. In fact, what he would probably do is maybe revoke benefits, not just take your citizenship, but revoke benefits, but put that aside for now. This entire process, though, right, is generally how things work, right? If the president takes some action, people challenge it in court, and at least in our system, we give the court the final word about whether those actions were lawful. If that's correct or not, we don't really need to think about it. But we saw something, I think, very different happen in the first days, weeks, and months of the Trump presidency, right? Put yourselves back to 2016, right? Remember, Hillary Clinton was destined to shatter the glass ceiling and pack the Supreme Court with the Liberal Alliance, right? The left dreamed of the day when federalism, the right to bear arms, religious liberty, would be exiled from the Constitution and replaced by a progressive jurisprudence they waited for. Instead of, having more Scalias, you'd have more Sotomayors. But that didn't happen. On November 8th, President Trump won the election. And the left woke from this nightmare to a painful hangover. The 45th president would shift the Supreme Court and the entire federal judiciary to the right. No Garland, Gorsuch. No Kennedy, Kavanaugh. So rather than advancing a liberal vision of the Constitution, now they're moving towards more of an originalist understanding of the Constitution. And why is this important? Progressive groups realized that they lost, but they needed a strategy. And they adopted, as we do today, hashtags as a strategy. And the hashtag became hashtag resist. And a number of these groups put aside their little rivalries to come together on a strategy that became known as legal resistance. Now, I didn't make this name up. They gave this name to themselves. And there's nothing wrong with groups that lose elections by using the courts. Republicans did this for the last 8 years. During the end of the Obama administration, you have Republican attorneys general challenging almost every aspect of what President Obama did. But what we saw in the early weeks, days, and months of the Trump presidency was something very different. And I think blame needs to be spread out through the entire process. Much of the discussion focuses on the travel ban. Now, we all know now in hindsight, the Supreme Court upheld the travel ban last June. But we have to keep in mind that that was the third iteration of the policy, called Travel Ban 3.0. The first executive order was released on January 27th, basically a week after inauguration. It was a disaster. It was an absolute disaster. It was basically drafted in the back of a cocktail napkin. I'm only slightly exaggerating. The idea was, effective immediately, with no advance warning, aliens from 7 nations, Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen, will be denied entry immediately to the United States. So imagine you were on a plane, right, crossing the ocean, and the order was signed. When you got on the plane, you were legal to come in, and when you got off the plane, now you're barred entry. Disaster. The order was also somewhat ambiguous, and they started blocking green card holders, right, lawful permanent residents from entering. People have a statutory right to enter the United States. Courts swept into action. Right? Almost immediately, lawyers filed suit, what are called habeas corpus writs, to get people out of captivity. And those I think were fine. But soon enough, you had the Washington Attorney General bring a lawsuit seeking a nationwide injunction barring this lawsuit from going into effect. I'm sorry, barring the order from being in effect. This judge in Seattle, James Robart, issued a temporary restraining order, basically a global injunction, not nationwide, a global injunction, worldwide, after 1 hour of oral argument, saying that the president's executive order must stop. You can read the judge's opinion. There's about 3 or 4 sentences of actual analysis, mostly boilerplate, and there's not really any grappling with the fact that a judge entered an order blocking this blocking this executive order. Okay? Now, why did this make me so upset when this happened? Now, again, I think the policy was very stupid. This is not going to keep us safer. It has no good sense behind it. But there's a statute. And the statute says the president can deny entry. The district court didn't even cite the statute, didn't even mention it. It wasn't relevant to him. You have precedent with past executives using this, not the way Trump did, but past presidents have used the statute in broad fashions. The court didn't grapple with that either. If you want to enjoin an executive policy globally, you need to do more than what this court did. Right? At that point, people who were locked in the airports had already gotten out. They were no longer in captivity, which I think is a good thing. But this policy had the effect saying that people can't enter for some period of time. He could have waited a day or two, right, while this policy was in effect, to write an opinion that explains why the president lacked his power, but it wasn't. It was just stop. There's this notion we have all too often that judges wear capes. As Justice Gorsuch reminds us, judges wear robes. And we can't rely on judges to save us from an executive who had just been elected, against my better judgment, to do these sorts of things that he promised and has the power to do. But it gets worse from there, right? So the district court entered a temporary restraining order, TRO, and the government filed an appeal. Now, I'm sure if you learn in civil procedure, you generally can't appeal a TRO, right? You can only seek what's called mandamus, which is a very extraordinary writ. So the correct remedy for the Ninth Circuit would have been to say, you know what, we're going to dismiss this because it doesn't meet the standards for mandamus. But instead they said, look, we'll just treat this as if it's a normal appeal. And they actually went on ruled on the due process clause, right? That President Trump's order violated the due process clause. No one ever talks about that. It was an insane argument. Right? They have a due process right to enter the country. That wasn't anywhere. But the court wrote an opinion, that was it. No one cared about it because that's the outcome that mattered. So again, you have neutral rules of procedure which are just being ignored. And fairly early on I wrote about this process, this sort of judicial resistance, which was what I called it, where the courts were simply not giving the president the sort of deference that is due in these circumstances. Now, we know ultimately the Supreme Court upheld the travel ban by a 5-4 vote. And it's often said, well, but the first version of the order was a mess. The last version was more refined. They had, they had findings. They made it a little bit more sufficient. The legal argument's exactly the same, right? If travel ban 1.0 is unconstitutional, then travel ban 3.0 is unconstitutional. If animus infected the third version, it infected the first version. I don't buy the difference. I think those all sink or swim on the same level. So then what do we make of the fact that these judges swept into action so quickly to halt and enjoin the president's order? And I think it was reasonable. I do think these judges were acting in good faith, right? The courts have this institutional norm that they're trying to maintain the separation of powers and guard against what they see as a threat to it. What President Trump does better than perhaps any other president ever had is take advantage of the power given to him and push things to the limits. And this is why I led off with the discussion of birthright citizenship. Congress enacted a statute, a very broad statute, that gives the president the power to deny entry to aliens. I think that statute's a bad idea, right? I would like a statute saying the president can deny entry for 30 days, then goes to Congress for permission. I like that with the War Powers Resolution, right? But Congress can do this. You can deny entry indefinitely. I think that statute might violate the non-delegation doctrine, give too much power. We have the statute. Now let's talk about birthright citizenship, right? We have statutes that say certain benefits can be given to a citizen. And the statute doesn't define the word citizen. Is the phrase citizen ambiguous? Can the president use various canons, such as Chevron, for example, to interpret the phrase citizenship and define it more narrowly than its predecessors? Right? The courts, again, have not ruled on the precise issue we have here. So the president can enact this sort of executive order, and then maybe in a year or so get struck down. Who cares? He got the political juice out of it. But the basis, right, and the reason why I think the criticism of Trump is somewhat misfounded is he's using the sort of authority that other presidents have had in the past in ways we just don't like. During the Obama presidency, I was very critical of sort of pen and phone governance, where the president can just write executive actions, executive orders, and reinterpret Title VII, and reinterpret Title IX, and reinterpret the Immigration Act to get for DACA, and then do DACA and all these other sorts of things. And you think these things are great, right? We need a president to help the immigrants. We need a president who can help people out. But when you let the president have this sort of unbounded discretion, it will invariably fall into the hands of a person that you deem dangerous. And that's already what's happened with President Trump. So the court left into action. Well, we can't have the president having this much discretion, right? You can't have this much discretion. If the statute says he can deny entry to anyone he wants, it can't possibly mean that. And I think that was shot down by the Supreme Court very quickly. So what we have here is a question, and now we're almost 2 years and change in the Trump presidency. Can we normalize Trump, right? Can we treat him as if he's a normal president? And I think the answer is the courts simply have to, and the lower courts hadn't, and the Supreme Court in Trump against Hawaii did. And there was one line in the Chief Justice's opinion that was very powerful. He said, this case is not about this president, but it's about the presidency. And distinguish the president from the presidency, because there's some long-term trends that are important here that sort of vanish when you're only talking about one person at a time. It's true that Trump consistently disrupts all political norms. The court should not respond in kind by disrupting judicial norms. And my hope is that in the next 2 years, the lower courts will take a cue from the travel ban litigation, the travel ban case, and recognize that you have to give the president some modicum of deference. I think we'll see this in cases involving DACA, right? If the president wants to wind it down, he'll get that discretion. I think we might even see it in cases involving whatever entry ban he puts at the border for the caravan, right? We'll see some more litigation on this as well. But the president has statutory authority. One president shall be declined from exercising. I'll stop here. Like my good friend, I'll come back up later. Thank you all so much. My computer? No, oh, goodness, I got extra. Please, I carry spares.
Why am I not?
My gift to you. An act of goodwill.
No, this is the wired one here.
So those of you who have had me in civil procedure or other classes probably understand that I'm not at all joking when I want this. I typically say at least once in each class, I'm only vaguely aware that we have a constitution. That is not my area of focus. I'm sorry. So I promise that this time I'll read the whole thing. A couple of other real quick caveats before I offer some remarks. One, this is actually the second time that this has happened with Federal Society where I am asked to debate or comment on somebody's talk with which I largely agree. And so this is not I'm not going to come up and say, here's all the ways that you're wrong, Josh, because I don't feel that way. And in fact, would generally find myself in support of most of the positions that you've taken. Although the opportunity to prepare for this has made me wonder and think through a little bit, okay, so why do I agree? And I think that that's useful to sort of figure out why do I find your position attractive, especially given that there are an awful lot of very smart and fairly thoughtful people out there who don't feel this way. And so that's kind of where I'm coming from. I also make one more sort of caveat, which is that if we are going to now govern by hashtag, we've gotten to a very dangerous place. I came up with my first hashtag this week in history, and it is in connection with the UVA Virginia football team, coached by Bronco Mendenhall. Here's my hashtag, decidedly competent. As far as I'm willing to go. Although that is such an improvement over the previous iterations of Virginia football that I'll take it. But I probably do not have much future in directing the policy of our land if hashtags are what's required. So I want to talk for a few minutes, and I think we'll have plenty of time for questions, but I want to talk for a few minutes about a couple of different things that you brought up, Josh. And one of them is this question about norms. And in particular, the position that I think I share, but I need to figure out why I share it, that the fact that we have a president who violates every norm known to the presidency, but in the history of the presidency, at least in the modern presidency, I would say the mass media presidency, we think that it's important that the judiciary not follow suit. And I think as you are from reading your stuff, I'm an institutionalist, right? I care about institutions. People think it's crazy sometimes. I'll actually take the position, but I believe it. I don't care what Congress does, as long as they've done it right. I am much less concerned about actions that a Republican or a Democratic Congress might take than I am about the fact that we've created a scenario that, for some structural reasons, makes Congress almost entirely dysfunctional for the last 40 years. And incapable, in my view, of almost entirely incapable of actually doing their jobs. But I don't necessarily care what the outcomes are, so much as I care about a structure and set of institutions that matter. But I do want to ask this. We talk, so in one of the pieces that I read in preparation for today, you talk about you're careful and in a very good way to separate your concerns about the merits of certain judicial resistance outcomes from your concerns about the procedures by which we got there. And in particular, you articulate a pretty powerful argument that we are, in order to get to where they're going. This is you talked about Judge Robard's opinion, right, out of Seattle. The way you spun it here suggested that you cared mostly about the fact that he didn't offer a whole lot of reasons. And I think that's fair, but I also think, and you've written elsewhere, what I think is more powerfully and more persuasively, that he also disregarded, as have a number of other courts, a number of judicial norms in order to even get to it. Right? Because there are judicial norms out there that we typically say, we're going to hold back on that one. Right? We have standing doctrines. We have a number of different things that are intended to impose a certain amount of institutional humility upon the judiciary, and they just blow right by that stuff. And am I correct that that upsets you? It upsets me.
Yeah.
Okay. And so here's my question. This is something I've been thinking about a little bit today. Is it possible that some of these judicial norms are more what I described to one of my colleagues, Stephanie Barclay, earlier, as a situation of making lemonade than as a genuine commitment? One of the things that is true historically about the judiciary reviewing executive action is that the vast majority of presidents have been a lot more careful about to not tell them exactly what I'm thinking. That courts have had to deal with an executive branch that whatever its true motivations are, that they know how to keep their mouths shut. And I honestly don't know if President Trump is expressing his heartfelt beliefs in his tweets, or if he is expressing a cynical political calculation, right? This is actually the result of him cynically realizing that this plays to a base that he needs to be motivated. But either way, he's just totally wiped sort of this norm of obscuring or protecting one's motivations from discovery by the courts. And so they do, right? The courts have played armchair psychologist with respect to Trump. We know what he was really up to in a way that I find disheartening and atypical, to say the least. But I also wonder whether, I'm going to be really cynical here. I'm a judge. I like the prerogatives of my office. I think that we are not the least dangerous branch, but the most. And I want to be, because I like that. And so I'm thinking, well, how do I maximize my power? I cannot, with a typical president, go in and say, I know what you were really thinking. And so maybe, as playing the long game, it makes more sense to adopt a norm of, we're going to be deferential to the executive branch. It's a sort of a judicial version of keeping your powder dry for when you can use it. Now, on the flip side, now I've got someone who tells me what he's thinking, right? And I know what the travel ban's about because I've got his tweets, right? And his tweets tell me that he is a xenophobe and a racist, etc. And so one of the questions I have is, to what extent is the real story behind violation of norms a story of norms that coalesce for everyone's good and sort of this noble evolution of norms as a good way, as protective of the republic? And to what extent is it, or to what extent is it instead sort of a reaction by the judiciary that this is actually that the norms that they have followed historically, deferential norms to the executive, actually preserve judicial power? Now, let me just to back away from that for a second. I don't know that it matters. In terms of and this is where I come down and I find that I agree with you largely. My view is that regardless of how we got them, how these norms developed, I kind of like them. In particular, I would like the president to stop tweeting. I mean, I really would. Because that's just, I think the technical term is deeply uncool. Not decidedly competent. But I would also like the judiciary to do it, to sort of retreat to its historical observation of norms, in particular norms, certain types of deference norms, because I think it is probably, regardless of how we got it, it's a good thing, right? It protects the republic. A couple of other thoughts. Let me see here. I'm not going to birthright citizenship. I was really upset when I saw that on the news because I thought, Josh is going to want to talk about that. So I don't want to talk about that because that's another thing I know nothing about. But I do think, I want to talk for a minute about, and this is sort of the classic, you'll recognize this very quickly, Josh, this is the classical Professor Hijack, right? Where I say, well, let me talk about something I care about. But I can eventually, it's like a book review, right, in the Michigan Law Review. Let me tell you my ideas. Oh, and then by the way, I looked at a couple of books and they suck. Here's one thing I'm worried about. I am worried about, from an institutional standpoint, the way that Congress doesn't do its job. And one of the things that I was talking to a colleague this morning, I've gotten very frustrated. My son, who's 16 and is very politically interested, asked me, he said, well, what has Mia Love accomplished? Exactly what she's supposed to have accomplished as someone who came in the 2010 wave. Nothing! Because that doesn't do her any good whatsoever. Right? We have a Congress that is, especially in the House of Representatives, something like this. Get elected 5 times, do nothing. Because doing something is very dangerous, especially when we talk about a 60% turnout rate in presidential election years, 40% turnout rate in midterm election years. It's all about motivation of the base. And making someone happy doesn't motivate nearly as much as making someone mad. And so she does nothing. If she can survive a couple more terms, all of a sudden she starts to get delightful committee assignments. And she becomes someone like my parents, who are the most rock-hard Republicans in the history of Republicanism, who nonetheless voted for Harry Bustamante, Democrat of San Antonio, for 20 years because he controlled the House Armed Services Committee, and he therefore controlled whether the Air Force bases that ran San Antonio's economy stayed open or closed. And so it becomes, so the political calculus is not one of what are they doing, so much as it is what can they do for me, and it's all about, perpetual reelection. And the worst thing to do if you want to be reelected is go do anything. It's a horrible idea. So that's my concern, is that I wonder whether some of this dysfunction that I think you are absolutely right to point out, the dysfunction between the legislative and executive branches, is in fact a function of larger dysfunction, that's a lot of functions, a lot of dysfunction within sort of the tripartite structure of our government. A couple of other little minor points. This is a question. It's actually sort of an empirical question, but I do wonder whether the confirmation of Brett Kavanaugh to the Supreme Court is going to radically change the calculus. And I've written on this, and Professor Nielsen has pushed me hard to write on this. Just say, look, you're here. You're both of you. Share the pain. But one of the things that I find fascinating is the extent to which the actions of lower courts, both the district courts, but in particular the courts of appeal, are motivated, at least potentially, at least partially, by their ability to insulate their decisions from review. And I'll be blunt, I think that they can do it. I think that they're very good at doing it in certain circumstances, and I think that there's evidence that they do it. And one of the things that I think we see now, bless you, with Kavanaugh, is that I think we have a swing justice, but I think the swing is totally different, right? I think that we have an institutionalist as our swing justice, right, in Chief Justice Roberts, and I think that that is likely to answer a lot of questions. I can see the Ninth Circuit, as they did in the travel ban cases early, being willing to roll the dice a little bit because they probably knew it was not going to be a cert-proof opinion, right? It was too darned important, but they thought they probably had a reasonable chance of getting an outcome that they liked because Kennedy is a wild card. I'm not sure that that's true anymore on some bases, and it's going to be really interesting to see over the next several years how, I think it's inevitable that we will have a swing justice, but the dimension or the dynamic on which Roberts is likely to swing is quite a bit different, right? Kennedy swung on sort of these, I am really smart and I want to leave a really lasting impression, and I want to write big sweeping opinions about things in ways that are just going to truly horrify anyone who thinks precedent should be carefully generated. Like me. Roberts is almost exactly the opposite, and so it will be really interesting to see, I think the cases where we're going to see 5-4s, more likely to be cases where there's a tension between political policy ends and protection of the institution. Now that said, I think Josh would agree that the Supreme Court has been more institutionalist in its orientation, even some of the more liberal justices, than the lower courts have been. And I think that they understand, for a variety of reasons, either because they're trying to protect their own prerogatives if you're cynical, or because they really value the institution, that they need to be doing a better job of protecting institutions than the circuit courts of appeal. Which then leads me to another question. This is even more cynical still. Do the courts of appeal and the lower courts continue to act this way if they know that, if they start to wonder whether they can rely upon the Supreme Court to be the protector of the institutional interest. And so I think back to, you know, so I think back to, this is, I told one student this once, I think back to the invasion of Iraq in 2003. And I think back to different countries' stated opinions on whether it was a good idea or not. And I think that there were some countries out there who really thought it was stupid or bad. I think there were some countries, I think France comes to mind, that really didn't like the idea that business deals they had in Iraq were likely to be sort of undermined by a U.S. invasion. But the ones that I found most interesting were those that I think felt free to condemn the U.S. invasion because they knew it was going to happen anyway. And so why not? Because I can score points with a constituency and get rid of a bad person that I don't like destabilizing the Middle East. And so that's some of the question I have is, you know, to what extent do some of what we see from lower courts in this score come because they know that there's a grown-up in the room in the form of the Supreme Court, or at least suspect there is, and if we lost that grown-up, what would happen? Okay, I think the last thing I will say, one of the things that I think is most challenging about this area, and I think it actually is what separates many of the thoughtful liberals and thoughtful conservatives of the day, is the huge disagreement about really difficult empirical questions. And strong priors that make us think, because I'm a liberal, because I'm a conservative, this must be true, but they don't know that. And so one of the things that I would ask just for you to think about as you guys are sort of developing and extending your own political identities, to what extent are you basing your conclusions on your own priors as opposed to data? And here's the empirical question. What is more destructive of the fabric of our republic? Is it undermining institutions like the judiciary or the executive branch? Or is it doing things that I think many people, maybe a majority of people, think continuing to countenance things that many people believe are genuinely unjust? I have an opinion, right? My opinion as someone who tends toward the libertarian side of the scale is that we have to protect the institutions and let the chips fall where they may. But it is resonant to me when I think back a set of cases from the 19-somethings, because I don't know about the Constitution, 50s, 60s, somewhere in there, the Commerce Clause cases, and I look at these and I do wonder, would my desire to protect what I think is the right limited interpretation of what the Commerce Clause is supposed to do be worth what it might have cost in additional pain and suffering to a group of citizens that have been categorically disenfranchised by my own home of the American South? I don't know. And so I would suggest that we all, at the very least, and I think institutionalism is more consistent with this, approach these problems with modesty and with humility. With that, I'll just go ahead and we'll for questions or whatever. And thank you for my time.
Finish at one? Yeah. Okay. Well, then you asked a lot of very good questions, which I don't have time to answer any of them. But I'll end on I think an uplifting note. The travel ban is one of those policies where I think all 9, maybe 8 justices thought it was a bad policy. Right? I'll just exclude Justice Thomas for a minute. But I think all the justices agree this is probably a bad idea. And Justice Roberts has some pretty harsh language, has some pretty harsh language about the policy in his opinion. But even though they thought it was a bad policy, they still found that it was lawful. As you make your way through law school, when you take different classes, whether Nielsen, or Sparkler, or anyone else, ask yourself, do I agree with this policy? If the answer is yes, say, do I think it's legal? How often do you present yourself with a case where you think, you know what, that's a good policy, but it's illegal? And how often do you present yourself with a case as, wow, that's a terrible policy, but it's lawful. The president can do that. And unfortunately, I find myself in that spot all the time. For better or for worse, mostly for worse, I think President Trump's policy has been pretty terrible. Not all of them. Some things are good, but mostly not good. But he's relying on what I think are fairly well-established delegations of authority. Delegations I think probably unconstitutional, but he's relying on them. And then conversely with the Obama presidency, I agreed with a lot of his policies. DACA and DAPA, I thought those were great policies. But I was fairly convinced that the immigration laws did not give him that breadth of authority. So keep this in mind, right? Whenever you something, if your priors, right, if your conception of policy maps entirely with your vision of constitutional law, then your name is Anthony Kennedy. No, I'm sorry. Then no, sorry.
Yeah, I agree with
It
you.
makes you very happy that I don't have to care what Anthony Kennedy thinks anymore. It actually makes you very happy. It doesn't matter. He gives a speech, I didn't even read it. Right? It's made no difference. It's just, come on. Freedom, isn't it? It's liberating, really, true. This is the sweet mystery of life. No, wait, it's like that beyond Anthony Kennedy. No, all right, let's stop here. All right. Anything else?
No, I actually would just echo the same thing, right? It is, we are increasingly, in my view, living, at least with in the popular media, in an environment where those two conceptions, right, what is good law and what is good policy, are conflated. And I think that my point about raising the empirical question is a way to think about, whether that, I just know that is not always true, right? I know that there are situations where I think that there are horrible laws on the books or horrible policies that have been enacted where my response is, as both Obama and others, Republicans have said, elections have consequences. I'm not thrilled with those consequences, but I am not willing to sacrifice the fabric of the republic in order to have my policy preferences enacted. Right? That's because, even if nothing else, you're going to lose an election someday.
So we're not just going to burn it all down?
No, I don't think we should.
Burn it down, burn it to the ground. All right, let's take some questions. Questions? Oh, what's leaving?
Oh, there's a right at one. So
Oh yeah. Okay. So Josh,
David,
you
you got
can go. You can just go.
Yeah. Do you think that any of this has to do? Are there some even judges who just kind of see law as power, and so I'm just here to get to the right answer? I mean, I feel like some people in the policy sphere definitely have that view. Right? They're just a hired gun.
So the question you can hear is: some judges see the role as one of power, and they do whatever they have to get to the right result. I try very hard not to charge people with bad faith. I work very hard to do that. It's often really tough, but I try. And to just say that judge is being political, I think is oversimplifying it. I think most judges, not all judges, try very hard to do their job. And they think that the Constitution, whatever the state statute is, gives them the power to do what they're doing. I don't think there's any judge says, you know what, I don't care what the law says, I want to reach for an outcome. But we're lawyers, right?
Judge Reinhardt is dead.
Yeah, well, no, he's still issuing opinions, though.
Oh, that's true.
But we're all lawyers here, right? And you can maybe be hired by the plaintiff and brief one side effectively, and you can be hired by the defendant and brief another side effectively, right? Usually issues go to court because they're debatable, and there's reasonable ground on both sides. Now, not always. Sometimes the case is very easy and the opinion's insane. I can give you some perhaps later. But I do think judges try. The difference is having who the grown-up in the room is, right? Is a grown-up in the room the court that says, no, Ninth Circuit, you can't do that? Or is the grown-up saying, oh my God, Fifth Circuit, you can't do that, right? Which one's the grown-up? And that's going to be large part based on elections who gets to pack the court.
So my response is similar. I have never yet met a judge, and I've met many at both the federal district and federal appeals court levels, who believed that their decisions were nakedly politically motivated. I'm sure that they may exist, or they may have existed in certain circumstances. I think but I think our collective capacity for self-delusion is pretty significant, and so I do think people will sometime. I mean, do I think that that's the functional effect sometimes? Yeah, but this is law; it's contested. There's almost always holes and ways to get kind of where you want to go. But I don't think it's as naked as, oh, goody, I'm a judge now. I'm going to impose the liberal conservative agenda, right? I think that's, there are constraints, and I think most of them are internal.
President Barker, want to ask something?
Although I have heard a speech by Judge Reinhardt.
Well, I left him out.
All right.
Okay.
But how he said it was interesting. He was talking to a different judge on the Ninth Circuit, and he said, "That's really interesting that you ruled a way you disagree because of standard of review. I would have found a way to get to the result that I wanted." And he just said that.
And I appeared before a judge in Milwaukee, Edelman, who just basically, his entire MO seemed to be, I'm going to find a way to make it difficult for the Seventh Circuit to overturn what I've decided to do here. Right? It does exist.
Findings of
But yeah, I
fact.
agree with that.
Exactly.
All right, student questions, maybe, not professor questions. Yeah.
Do you see any role of whataboutism in this debate? Because I feel like, I mean, it's hard to, at one point you want to be intellectually honest, but it's hard when those who had no problem with Obama and his executive amnesty, and they don't, where were they for that, but now?
Yeah, so I mean,
So what, how do you parse that?